It was like right around 2:30 or 3:40. Yeah, so I think we're gonna start around 4. Yeah.
Oh, tell you what, I only made up my primary vote within 20-minute speech. Oh, that's a
Yeah, exactly. That's all I'm saying.
yeah. At the end of the night,
Yeah. It's fun.
we'll figure it out. Don't you worry.
Okay.
Senator Blumenthal.
Thank you very much, Mr. Chairman. Thank you for being back, Your Honor, and thank you to your family as well. I want to just begin by saying, perhaps not surprisingly to you, that I was really disappointed by your responses to a number of my colleagues, most recently to Senator Coons, on the issue of whether you would participate in a decision involving the upcoming election if you are confirmed. I continue to believe that if you were to participate in a decision involving that election, it would do enduring explosive damage to the court. I think you know it would be wrong, not because of anything you've done. In fact, I'm not raising the issue of whether you've done any sort of deal or commitment because of what Donald Trump has done and my Republican colleagues, because they have indelibly put at issue your integrity through their statements. The president has said that he's putting you on the court as a ninth justice so you can decide the election. He's been very clear and transparent. And the American people are not dumb. They're watching and they're listening. And if you were to sit on this case, if it goes to the Supreme Court, the American people would lose faith and trust in the court itself. It would be a dagger at the heart of the court and our democracy if this election is decided by the court rather than the American voters. So I wanted to begin by making that point and then go to, again, the real people who are really in this room with us and who will be affected by you as a justice. Yesterday, I introduced you to Connor Curran. You may recall, he's 10 years old. I was with him on his 10th birthday, September 27. He's a remarkable champion. He was diagnosed, as you may remember, with Duchenne muscular dystrophy at age 4. His parents were told to take him home and give him a good life because he would soon lose his ability to walk, told his muscles would get so weak that he'd eventually lose his ability to smile, and still smiling. What lies behind that smile is untold pain, physical pain, the anguish of going through the needles and the prodding and the treatments. But for his family, it's also the anguish of wondering whether they'll be able to pay for treatment that has kept him alive and whether he will be with them for all of life's milestones. They sent me a letter that they asked me to share with you, saying to you, Judge Barrett, please protect Connor. And they wrote also for millions of other Americans, 135 million Americans, many of them children, just like Connor, but also Christine Miller from Bloomfield, Connecticut. She was diagnosed with a thyroid condition. Her condition was only discovered because of the ACA, which gave her affordable coverage for the first time in a long time using Connecticut's exchange, healthcare exchange. And they wrote for people like Julia Lanzano in Cheshire, Connecticut. She suffered from headaches for years, and she put off going to a doctor because she lacked insurance, so typical and common for people. Put it off. When Julia finally saw a doctor still without insurance, she learned she had a brain tumor, and she was eligible for coverage under Connecticut's Medicaid expansion program, which was created by the Affordable Care Act. In her words, it was a godsend. I raise these stories in part because, as you know, I'm sure, protection for people who suffer from pre-existing conditions is in fact on the line in this case that will come to the Supreme Court only a week after the election. I want to be crystal clear because you stated to Senator Feinstein that, and I'm going to quote, so far as I know, the case next week doesn't present that issue. It's not a challenge to pre-existing conditions coverage or to the extreme lifetime maximum relief from a cap. And technically, you're right, but it's a big but. If the trial court is upheld and there's no severability, the entire act goes down. That is what the Trump administration is asking the court to do. That's what the plaintiffs want done. Correct?
I gathered that's Senator Coons had shown the brief with the litigating position
Right.
of the Department of Justice.
I want to move on to another healthcare case. And this one involves some of the letters that Senator Hawley was mentioning. And I feel I need to raise them because Senator Hawley asked about them, so did Senator Leahy. And I want to just clarify what they mean. And I want to make absolutely clear, I detest and oppose any religious test. I am not asking you any questions about your religious beliefs.
Okay.
I'm going to be asking some questions about your legal position. So in case I'm unclear in any of my questions, I want you to tell me.
Thank you, Senator.
You signed onto this 2006 open letter sponsored by an organization then known as the St. Joseph's County Right to Life, which was published in the South Bend Tribune. Is that the letter that Senator Hawley was mentioning?
I believe the statement that's on the left, I think Senator Hawley had read the language. I can't remember it verbatim, but it was something like, you know, we support the right to life from fertilization to natural death. Yes.
The letter and ad referred to Roe v. Wade's legacy as quote unquote barbaric, correct?
I don't think that that's part of the statement. I think that's part of the ad that appeared on the page next to it.
They appeared side by side, correct?
I believe that it ran that way in the newspaper. I'm not sure that I ever saw it in the newspaper, but yes, that is my understanding.
That's how it appeared, so they were side by side.
That's based, yes, based on since, yeah.
And the St. Joseph's County Right to Life sponsored the letter that you signed.
I think the St. Joseph County Right to Life organization was the one who presented the statement that I signed at the back of church.
I want to give you an opportunity to clarify. You didn't disclose that letter when you were nominated to the 7th Circuit in 2017, did you?
I did not, Senator Blumenthal, and I'm actually very glad that you brought that up because I just want to clarify for the record. Number one, that I didn't have any recollection of that letter. I signed it almost, or the statement. I signed it almost 15 years ago, quickly on my way out of church. And, you know, this questionnaire asks me for 30 years worth of material, and I've produced more than 1,800 pages. And so I didn't recall it. After it came to my attention, I did go back and look at the questionnaire, and I actually don't think that particular statement is responsive to question 12, which is, I think, the closest that it would come. I don't think it's responsive, but in any event, it is part of the public, you know, record, and I'm very happy to discuss it. But I
It's
wasn't
part of the
hiding
public
the ball.
record now, and it's a letter. The questionnaire asks for letters. Have you disclosed it now? Have you provided it officially?
So Senator, as I said, I've supplemented my questionnaire with other material that came to light that I do think was responsive. That one, and I would be happy to answer questions if you wanted questions for the record with more specific detail, but I did not understand that to be responsive to question 12, I think it is.
Well, in fact, we know about it only because The Guardian made it public, I believe. Let me ask you about another letter, 2013 letter.
Mhm.
You signed on to this letter regarding Roe v. Wade. It was sponsored by the University Faculty for Life at Notre Dame. You're a member of that organization, correct?
I do.
And the letter described Roe v. Wade as, it's behind me, infamous. And it stated that the signatories, quote, renew our call for the unborn to be protected in law, correct?
Yes, I believe the full statement says, I'm testing my eyesight here, our full support for our university's commitment to the right to life, because, you know, Notre Dame is a Catholic university and embraces the teachings of the Catholic Church on abortion. And so as a faculty member and member of the University Faculty for Life, I signed that statement.
But you didn't disclose that letter
Again, Senator, I produced 1,800 pages of material, and all 6 prior nominees have had to supplement because they've overlooked things. 30 years worth of material is a lot to try to find and remember.
You disclosed it, in fact, just about 3 days ago, I believe, right?
Because that's when it was brought to my attention. I had no recollection of it, and it surfaced in the press, and so it came to my attention, and then I supplemented. And I did think it was responsive because it was a statement of an organization of which I was part, and I belonged to the University Faculty for Life at the time.
If this process maybe had been a little less rushed, you might have had more time to go back and recall some of these documents?
Well, Senator, as I said, all 6 prior nominees, or the most recent 6, have had to supplement too. So I don't think it really had anything to do with time. I think it has to do with the volume of material.
And when you and I spoke, when you appeared before this committee in connection with your 2017 nomination, I didn't have the benefit of any of these documents, although I asked you about right of privacy and the validity of Roe v. Wade, correct?
Senator, I said on my SJQ when I was nominated to the 7th Circuit, and I said again now, I produced all the material that I could find, and I conducted searches to try to find things that I forgot, and I didn't find that. I understand that someone had to manually go to Notre Dame and look through back archives. I didn't remember it, and I couldn't find it. I assure you I was not trying to hide it from you.
So, Judge, and I apologize for interrupting you. I'm
No.
pressed for
go ahead.
time.
Sure.
Respectfully, I want to share another healthcare story with you. This is about Samantha. One night in January 2017, Samantha went out with a few friends and coworkers. She woke up the next morning in a coworker's home, confused, scared, covered in blood. She'd been raped. After she was raped, Samantha was, in her words, a zombie. She couldn't change clothes, she couldn't shower, she couldn't drink or think. She wanted this event to be erased from her memory. Samantha's attacker also began stalking her, and she was struggling with depression and PTSD. In March, Samantha took a pregnancy test, and then another, then another. They kept coming back with the same result: pregnant. After the horrible violence she faced, she simply couldn't process that she was now pregnant. When Samantha shared her story with me, she said, "I knew if I couldn't end this pregnancy, it would end me." So she decided to get an abortion. Now, as you know, Judge, the landmark Roe v. Wade decision gave her that option. It gave women the right to decide for themselves whether and when to have a child. Roe didn't compel Samantha to get an abortion. It didn't tell her what she had to do, but it gave her that choice. The question that I would like to ask you concerns your legal position. Does the Constitution protect Samantha's right to have an abortion?
Roe versus Wade clearly held that the Constitution protected a woman's right to terminate a pregnancy. Casey upheld that central holding and spelled out in greater detail the tests that the court uses to consider the legality of abortion regulations.
Now, I'm asking you this question because the group that sponsored the first letter, St. Joseph's County Right to Life, as it was then known, states, quote, "Abortion is never the right answer, even in cases of sexual assault or where the pregnant woman's life is in danger." And the purpose of the letters that you signed seem to be a statement of legal position, but you're saying that there is a constitutional right to an abortion.
Senator, the statement that I signed from the St. Joseph County Right to Life didn't say anything about rape or incest or any of those things. It simply validated the teaching of my church on the sacredness of life from conception to natural death.
What I hear you saying is, in the Constitution, there is that right.
You mean when I was talking about Roe and Casey a moment ago?
Well, Roe was correctly decided. You're agreeing that,
What I said was that Roe held that the Constitution protects a woman's right to terminate a pregnancy, that Casey reaffirmed that holding, and indeed, many cases after Casey have affirmed that holding again, Whole Women's Health, for example. So I think we might be talking past each other because the statements that I signed were statements of my personal beliefs and not
not your personal belief, Your Honor, your legal position. Are you willing to say that Roe was correctly decided? Because that's really the essence of the question here.
Well, Senator, as I've said, to others of your colleagues in response to questioning, that it's inconsistent with the duties of a sitting judge. And therefore has been the practice of every nominee that sat in the seat before me to take positions on cases that the court has decided in the past.
Well, I think Samantha and a lot of rape survivors would be really deeply fearful about that answer because it provides no reassurance that you believe that Roe was correctly decided. Let me talk about Tracy. I want to tell you about her because she, again, came to me, told me she was diagnosed with stage 4 endometriosis and that it had caused an ongoing inability to have a healthy pregnancy. But as she said, she was one of the, quote, lucky ones. She had access to care and was able to receive treatment to assist in getting and staying pregnant. And I have encountered, maybe you have, many members of the military, veterans, who have sought similar kinds of treatment, and some of them because they've suffered wounds of war. Tracy was scared when she saw the executive director of the St. Joseph County Right to Life recently stated, and I quote, "We would be supportive of criminalizing the discarding of frozen embryos or selective reduction through the IVF process." So Tracy wanted me to ask you, in fact, she asked me to pose this question, is it your legal position that making IVF a crime would be constitutional?
Well, Senator, the statement that I signed, as we discussed, affirmed the belief of my church with respect to matters of life.
I'm
But
not
you're-
asking about what you signed. I'm asking about your present legal position.
But what I was,
Is making IVF a crime
Senator, you're,
constitutional? Sorry, go ahead.
sorry, I was trying to answer. But you're quoting positions from the St. Joseph County Right to Life. I'm not a member of that organization, and so I'm not responsible for statements that they make. The statement that I signed said what you and I have discussed, and it said nothing further than that. And as for, what policy position someone might take, as I've said to your colleagues, it's not up to me to be in the business of expressing views. And I am happy to talk about views that I expressed when I was a private citizen, but now I'm a judge, and so I cannot publicly express views.
Just to be absolutely clear, I'm not asking about the St. Joseph County Right to Life or their positions. And I understand you may or may not disagree or agree with them, but your legal position, IVF treatment, and I'm not going to ask again, just this last time, criminalizing it,
Well,
would it be constitutional? I think there's a clear answer.
but Senator, I've repeatedly said, as has every other nominee who sat in this seat, that we can't answer questions in the abstract. That would have to be decided in the course of the judicial process. With a case, some legislature would actually have to do that, and then litigants would have to come to court. There would have to be briefs and arguments and consultation with colleagues and opinion writing and consideration of precedent. So an off-the-cuff reaction to that would just circumvent the judicial process.
Well, again, I'm disappointed. I think Tracy would find that response somewhat chilling, because she and thousands, maybe millions of women, potential parents, would be horrified to think that IVF treatment could be made criminal. And I understand you're not answering the question, but I think she would be deeply fearful. Do you think that it would be constitutional to make it a crime for doctors or healthcare providers to provide that care or abortion care?
Well, Senator, again, that's a hypothetical question. And so, as I've said, to give off-the-cuff responses about abstract issues, and I should clarify to say, it really doesn't matter if they're hard questions or easy questions. It's just any questions that call for an abstract legal opinion are not ones that are appropriate for me to give either as a sitting judge or as a nominee. Those questions in my judicial role can be answered only through the judicial process.
Just to be absolutely clear, there are millions of women like Samantha and Tracy and the veterans I mentioned who are terrified to think that their doctors and healthcare providers would be potentially in jail at risk of prosecution. Doctors who are exercising currently protected rights that Samantha says saved her life. And I believe our healthcare providers are heroes, particularly during the pandemic. But I want to ask you one more question about these documents. In the 2013 letter that you signed, there is the following statement. We renew our call for the unborn to be protected in law, and welcomed in life. What does it mean for, quote, the unborn to be protected in law? Does that statement mean there is no valid constitutional protection for an abortion, and therefore Roe v. Wade should be overturned?
I think that statement is an affirmation of life. It points out that we express our love and support for the mothers who bear them. Again, it was a statement validating the position of the Catholic University at which I worked in support for life and to, support women in crisis pregnancies, to support babies. So it's really no more than the expression of a pro-life view.
I expect we'll be talking more about this issue tomorrow. I want to move now to another topic. You and Senator Durbin and others talked about your dissent in Cantor v. Barr. And I think your approach here, in effect, usurps the legislature's appropriate role in making policy judgments. In the case of Cantor, which, by the way, you put first on the list of decisions that you thought were most important that you have written. Is that correct?
I don't remember the order in which I listed them.
It was first.
I accept that. I just don't remember the order.
Okay.
I did list it. I remember listing it.
Okay. But that decision seems to usurp the legislature's role in deciding who should be permitted to have firearms and who should not, because you decided the legislature was wrong to classify felons as not deserving of firearms. You decided as a matter of policy that when they were not dangerous, they should have that right. That's a policy or legislative judgment. And I think it has huge ramifications for real people across the country. And I want to tell you about one of them from Sandy Hook, Connecticut. Natalie, who is shown here with her brother Daniel. Daniel was killed at Sandy Hook Elementary School in Newtown, Connecticut on December 14th, 2012. Daniel was 7. I was there that day. Saw the parents after they'd learned that they had lost 20 beautiful children. And 6 great educators died as well. In the firehouse that day, there was unspeakable grief. And 8 years later, Natalie says that grief remains with her. But Natalie, like Newtown, is resilient and strong, and her grief and trauma spurred hope and action. She and many young people across the country are leading a movement to deal with the epidemic and scourge of gun violence in this country. What happened at Sandy Hook was not an isolated instance. There have been 236 other mass shootings in the last decade. In the last 10 years, gun violence has taken more than 354,000 lives in rural communities and urban communities all around the country. And I'm sure in Indiana and South Bend as well. Your opinion in Cantor goes farther than Justice Scalia in Heller. In fact, you characterized it as kind of radical. It is, in effect, an outlier. And it is, in fact, radical.
Did I say it was radical in the opinion?
I think you said, quote, "It sounds kind of radical to say felons can have firearms." That's a direct quote.
Oh, I didn't remember that particular language.
You can.
I'm
Change.
not, I just don't recall it, but I'm not nitpicking about it.
We can look it up.
That's fine, Senator. I don't think you're making it up. Trust me. No, I'll check it and look it up. But I know that's not the thrust of your question.
It sounds kind of radical because it is radical. In fact, no courts of appeals, except maybe the 7th Circuit, has adopted this reasoning.
The 3rd Circuit, I think, has a rule that's.
The 3rd Circuit. Any others?
I don't know that it's
I
come
think
up.
I
in
knew there
others.
was one
3rd
circuit that did. I wasn't sure which one. But thank you.
My position was consistent with a 3rd Circuit en banc decision that had already been decided.
And cutting through all of the legalese, and we've had quite a bit of it going back and forth, what this approach does potentially is mean that Connecticut's gun safety provision that the people of Newtown, Kristen and Michael Song, on behalf of their son Ethan, who perished because of a gun that was unsafely stored, they championed a measure called Ethan's Law. Common sense measures that might have prevented the death of Shane Oliver, Janet Rice's son, who died on October 20th, 2012. Shane was killed when he was 20 years old in Hartford. He died fighting for his life in Hartford Hospital. And measures like the emergency risk protection order that Connecticut now has. 19 states have these laws. They've saved lives. And extreme risk protection order laws, which help minimize risk, might well be struck down under the reasoning of your dissent.
Respectfully, Senator, my dissent would not reach even those issues. My dissent was about the narrow question about whether a felon who had sold fraudulent foot inserts could automatically be disqualified from his Second Amendment rights simply on that basis. It said that guns can be kept out of the hands of the dangerous, and it didn't say anything about other gun safety or background check. Those are all issues that are being litigated across the country and were not at issue in Cantor.
but supplanting the legislator's judgment about when dangerous people should be protected from themselves if they are potential suicides, as Vic Bencomo, a veteran in Iraq, found when his friend was going to take his life. The emergency risk protection order would have been available, deciding what is dangerous, who is dangerous, when weapons should be taken away from them. If the courts are going to supplant the judgments of legislatures, if judges are going to legislate from the bench, that's the import of your reasoning in that dissent. It may not have dealt precisely with any of these particular laws, but the reasoning throws into doubt. It raises the risk to many of them. And folks who live in Connecticut are terrified of that prospect, at least
Well,
many
Sandy
who've
Hook
talked
was
to
a
me.
tragedy. So I express the deepest sympathy for those who experienced that loss there and elsewhere. But Cantor, I hope you take some comfort from Cantor being a much narrower decision that doesn't have any effect on those sorts of laws. Thank you, Senator.
Thank
Blumenthal.
you. Thank you, Judge.
Senator Tillis.
Thank you, Mr. Chairman. Thank you, Judge Barrett. Mr. Chairman, before I get started, I'd like unanimous consent to submit a letter from my primary care physician indicating that I fully complied with CDC guidelines, being cleared like 2,000 other North Carolinians yesterday, and I'm glad that they're healing.
Without objection.
I'd also like to put forth 3 letters in support of Judge Barrett, including one from Devin Patel, a former student who speaks very highly of your academic prowess, but also your compassion.
Without objection.
Also like to cover what Senator Blumenthal just did. I think we should go back. I believe you alluded to it, Judge Barrett, but question 12A of the committee questionnaire asks for books, articles, reports, letters to the editor, editorial pieces, or other published material you have written or edited. Is it fair to say that if you signed a petition, you did not write or edit any of the petition you signed?
I did not write or edit that.
It's also needs to be restated. I think you alluded to it, but over the last 6 justices confirmed by this committee, all of them provided supplemental information, and in some cases after the actual hearing. So I appreciate your being forthcoming, that you've submitted 1,800 pages of documents. Mr. Chairman, just going back, I also wanted to mention that as a part of my journey through my time in quarantine, I have enrolled in 2 studies so far. I'll be giving blood on Friday to enroll in another program at UNC Chapel Hill, and I'm scheduled to donate convalescent plasma. Because this is being aired, I hope that anyone who's recovered from COVID will do their part to try and heal this country from the health challenges that COVID has presented us with. I intend to do my part. I also would like to say, I like to consider the Senate an essential business. And I believe that the architect of the Capitol and our attending physicians here have taken great measures to make sure that we can safely come to work. And I would encourage anybody who works in the Senate to come to work. I want to also go back to something that Senator Feinstein said earlier, and you're not going to have to answer this question. Senator Feinstein mentioned earlier that we've had a surge in applications for guns or purchases of guns. I wonder if a part of that is where we find our society right now. We're seeing great cities burned and looted. In my highway patrol in North Carolina, 75% fewer applications to go into the Troopers Academy and record high requests for retirement. We see that in New York. We see it across this country. I think people are afraid because many people, including people on this committee, are unwilling to condemn the acts of violence in public safety out there and condemn violence against law enforcement, which is rampant. I lost a sheriff's deputy just about a month ago who was shot protecting a family. So yes, Senator Feinstein, I suspect that gun purchases are up, but I suspect the root cause behind a lot of them have to do with people's personal safety. To your family, I would encourage all your family members and your students who mercifully are your children who are your students too. who are mercifully taking a break, to treat social media like roadkill. Just don't look at it, because if you do, you're going to regret it. I am going to also ask unanimous consent to put forth some articles or tweets from prominent people that I think kind of give you an idea of the guerrilla tactics that are being used right now. In the committee, this has sounded a whole lot like a lobbying session. It's almost as if you're being interviewed to become a U.S. senator so that you can decide policy on the Affordable Care Act and a number of other things that I'll get to. But behind the curtains, we're seeing people say all kinds of things about you. One called you a white colonizer for actually adopting 2 Haitian children. We have another one calling you a handmaid and a clown car. And it will be submitted for the record, but the profanity used in there. Another one that says that, yeah, you're a good mom, but that doesn't qualify you as a judge. What qualifies you as a judge is being an extraordinary professor, an extraordinary student, and an extraordinary jurist. And I think that these people need to recognize doing the bidding of this committee by attacking you outside of the committee is as bad as them being in this chamber. Now, I also want to talk about the discussion on Roe v. Wade and the Affordable Care Act. Senator Feinstein, in I think the same 2 or 3 minutes, said that she wanted you to protect Roe v. Wade, but overturn Heller. Those seem to be incongruent, but I'll just leave that out there. They're asking you to basically legislate. I don't want you to do that. But when we talk about Roe v. Wade, the one thing that's conveniently missed about this discussion is something that I think that most of the American people are at odds with the position that every member of the Democratic Conference supports. My granddaughter went to her 2-month health checkup today. She weighed in at 10.1 pounds. And you can't see this picture, but I'm telling you, from this granddaddy's eyes, she's gorgeous. But she was born 3 weeks premature, and she only weighed a little over 6 pounds. She was discharged from the hospital within 36 hours. My colleagues on the other side of the aisle want to talk about the broad strokes of Roe v. Wade. They don't want to talk about their radical policy that would allow the right to take that child away that I just held in my arm 2 or 3 weeks ago, and 8 weeks ago when she was 3 weeks premature. Judge Barrett, I believe I have complete confidence in your integrity. I have complete confidence that you're going to go and you're going to be a great justice. But I do want to ask a little bit about maybe your experience when you were working for. Actually, I want to start when you were in school. When you came in, you were obviously a brilliant student. You did your homework. We've heard professors attest to your intelligence and your performance in school. Did you ever go into a classroom where the professor was espousing one position and you were espousing another one, and you ended up coming out with a different perspective?
Sure.
Yeah. Did you ever change your professor's perspective?
I'm not sure about that.
Well, it's kind of an unfair balance. Okay, now fast forward to when you were a clerk for Justice Scalia. I just saw an interview last week when I was in quarantine of Justice Breyer talking about these mounds of documents that his clerks would provide him. He'd quickly go through them. He said it's actually a fairly quick process to winnow out the ones where there's no dispute among, there's no split circuits. So you move through it pretty quickly. I understand that Justice Scalia, at least in some sessions, would have a mix of clerks. They would be across the ideological spectrum. Was that the case when you were clerking for him?
I would say that not all 4 of us, he had 4 clerks, and we were not all of the same mind. There was a mix.
Were there ever cases when you went before Justice Scalia and you thought that maybe he was leaning one way, where he actually listened to the arguments from the clerk and modified his position? Or was it like the professor discussion?
No, I think he definitely listened. I mean, we would go in before an argument when he was preparing, and he would pepper us with questions and go back and forth. He wanted to hear it from all sides. And so, no, he definitely, it was part of the give and take, though, to be clear. He was the one with the commission, and he was the one who made the decisions.
Thank you. The last thing I'm going to say, because I want to yield back more time than most other members, is, Mr. Chairman, you opened up this morning talking about the Affordable Care Act. I don't think there's anybody in the U.S. Senate that doesn't want to make sure that every single picture that we've seen here, that those folks have affordable health care and that they can be cared for. But what we have here in the Affordable Care Act is something that is so flawed that the majority of the Democratic candidates for president all raised their hand and said it needed to be replaced with something they call Medicare for all, which could be Medicare for none. We know the broken promises of if you like your doctor, you could keep it. If you like your health care, you could keep it. What we're not talking about are the thousands of people who were already forced off of their job health care because employers changed hours. And now instead of working one full-time job, you've got to work 2 full-time jobs because the businesses can't afford it. We've got a fundamental problem here. We need to protect every one of them, but we also need to make sure that people who have a health plan under the Affordable Care Act can actually afford to use it. In the catastrophic situations, it's life-changing, and thank God that it's there for them. But what about so many other people that only have it and will only use it if they have a catastrophic situation because they can't afford the co-pays, they can't afford the underlying costs? We need to fix that. We shouldn't expect a justice or the Supreme Court to fix it. That is our job. We should all show up here for work, and we should get that done. And we should also work on all the other things that this country is suffering from as a result of COVID. Thank you, Judge Barrett. I look forward to supporting your nomination.
Thank you, Senator Tillis.
Thank you. Senator Hirano.
Thank you, Mr. Chairman. Mr. Chairman, I want to reiterate my objections to holding this nomination hearing instead of working to provide relief for the millions of Americans who are suffering during this pandemic. 3 weeks ago, our country crossed a tragic milestone. We lost more than 200,000 Americans to COVID-19. That is more than the entire population of the Big Island in Hawaii, more than the population of Tempe, Arizona, Cedar Rapids, Iowa, Wilmington, North Carolina, Charleston, South Carolina, Waco, Texas. I could go on. 200,000 American lives plus. This is a photo of a memorial outside the White House where President Trump held a reckless super spreader event 2 weeks ago to announce the Supreme Court nomination. The memorial shows 20,000 empty chairs, one chair representing 10 American lives lost to COVID-19. And one of those chairs represents Veronica Guevara's grandfather, who is pictured here with Veronica. Veronica, who is from Iowa, has experienced the painful impact of the Trump administration's failure to address the pandemic. Her family is composed of essential workers who are working on the front lines of this pandemic. Her mother, who worked at a fast food processing facility, caught COVID-19 at work and was eventually hospitalized for 7 days. Thankfully, her mother recovered, but then her grandparents got COVID-19 and were admitted to the hospital. And although her grandmother recovered, sadly, her grandfather didn't make it. After experiencing all of this tragedy, Veronica shared, quote, "It is even more so insulting to see a Senate that is more concerned with rushing through a Supreme Court nominee rather than focusing on providing relief to all the hardworking people that gave them their current leadership positions." End quote. Many Americans agree with Veronica. They are sitting at their kitchen tables wondering how they're going to buy food, how they're going to pay rent. Millions of them are they don't have jobs. They're going to food banks for the first time in their lives. So rather than coming up with a bill that meets the needs of the urgency of this moment, Republicans are just coming up with piecemeal bills. That's because we know that within your own caucus, you can't agree on one bill that fits the critical needs of this country. In fact, there are at least 20 Republicans we heard who have said, we're done, we're not doing any more to help the Americans who are suffering with COVID. So here we are racing forward with this nomination while the rest of the country is wondering, what the heck is the Senate doing, particularly the Senate Republicans? So I agree with all the people in our country who are asking, what the heck? This is hypocritical. This hearing shows the American public exactly what my Republican colleagues' priorities are, ramming through another ideologically driven justice to the Supreme Court instead of helping the people in our country suffering during this pandemic. Mr. Chairman, I have some letters of opposition to Judge Barrett's nomination to enter into the record. These are letters from Lambda Legal, the Japanese American Citizens League, and the National Asian Pacific American Women's Forum, which was joined by 55 reproductive justice groups. I ask unanimous consent to enter these letters into the record.
Without objection.
Judge Barrett, Chief Justice John Roberts has recognized that, and I quote him, "The judicial branch is not immune," end quote, "from the widespread problem of sexual harassment and assault, and has taken steps to address this issue within the judiciary. As part of my responsibility as a member of this committee, and indeed all of the committees on which I sit, to ensure the fitness of nominees for a lifetime appointment to the federal bench or to any of the other positions for any of the committees on which they appear, I ask each nominee these two questions, and I will ask them of you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator Hirono.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No, Senator.
Judge Barrett, do you think it is appropriate for justices to consider real-world impacts in their decision-making, as Justice Ginsburg noted in a number of her dissents?
Well, Senator, the doctrine of stare decisis is a good example of that because the factor reliance interests takes into account the real world impact, the way that people have ordered their affairs and relied on decisions. So there are contexts, yes, in which considering the impact is expressly part of the doctrine.
So you would say then that you've been listening to all of us here yesterday as well as today talk about the real world impact of the striking down of the Affordable Care Act. And would all of those impacts be factors that would be important for you to consider should you be a justice?
Senator, to be clear, I have the utmost empathy. The stories, that you have told, including the story of Veronica's family, are very moving. If I were a justice, the commitment that I would make to you and all people affected by the laws is that I would follow the law as you enacted it, and I have no agenda. I would not be coming in with any agenda. I would do equal justice under the law for all and not try to thwart or disrupt in any way the policy choices that you and your colleagues have adopted.
So are you saying that the impact of the Affordable Care Act on the millions of people who rely upon it, that those who you would deem to be policy considerations that we should address?
Senator, I think that you choose the law and you've structured the Affordable Care Act. It's a complex, long statute. I think you set the policy. And then I think when a court has to interpret the statute or decide how it applies in a certain circumstance, the court looks to traditional legal materials, looks to the briefs. It listens to the real world impact on the litigants who are before the court arguing the case, because every case affects real litigants. Every case affects real people. I said in my opening statement yesterday that, when you pass statutes, they're often named for the co-sponsors of the bill. But cases decided by all courts are typically named after the parties. They affect real people.
Judge Barrett, so are you saying that all of the stories that we brought forth yesterday and the millions of people who are relying on the Affordable Care Act can rely upon you, that those impacts would be considered by you, that you would consider those to be legal arguments that you would consider? Because when you say that you're going to make a decision based on the law, the real life stories that we've been talking about, you would consider those to be part of the law?
Senator Hirono, every case that comes before a court, because as I was saying earlier, no case comes before a court unless it involves real live people who've had a real live dispute. And it is the job of a judge deciding every case to take into account the real world consequences of the parties before it.
So does that mean that you would agree with Justice Ginsburg that the court should be taking into consideration the real life effect of the decisions that they make? Because she wrote a number of dissents saying that the majority did not consider the real world impacts of their decisions. So are you aligning yourself with Justice Ginsburg in terms of what you would consider real life impacts and the effect it would have on your decision regarding the law?
Well, Senator, I don't know what context, the particular context in which Justice Ginsburg was describing that. I think what I'm trying to align myself with is the law, and that I will take into account all factors, including real-world impacts, when the law
Mhm.
makes them relevant, as it clearly does, for example, in the doctrine of stare decisis.
I'll get to your views of precedent in a moment. I'll give you a real life example of Justice Ginsburg. In Ledbetter v. Goodyear Tire and Rubber Company, Lily Ledbetter worked at a Goodyear plant for 19 years. As an area manager, a position held mostly by men, Lily was paid less than all of her male counterparts. When she eventually realized this stark inequality, she sued for pay discrimination, and a jury agreed. But the Supreme Court kicked Lily's claim out of the court for being too late. The conservative majority, including your mentor, Justice Scalia, interpreted Title VII's 180-day time limit to mean that Lily had to have filed her claim within 180 days of when her salary was decided, instead of accepting the common sense approach of viewing her paychecks as an ongoing part of pay discrimination. Justice Ginsburg strongly disagreed with her conservative colleagues' approach to the case. In her dissent, she pointed out the many challenges women face in discovering pay disparities, including how many companies keep salaries confidential. In a stinging rebuke, she said, quote, "The court does not comprehend or is indifferent to the insidious way in which women can be victims of pay discrimination," end quote. In another case, in 2018, in Epic Systems Corp v. Lewis, employees who had been illegally underpaid joined together to seek back pay in court. To block this effort, their employers forced them to sign an arbitration agreement prohibiting collective actions. They actually had to sign these arbitration agreements in order to even have a job, keep their job. So the Supreme Court's conservative majority, including Justice Scalia, sided with the company. They interpreted a general federal arbitration law to override two worker protections laws instead of recognizing that the worker protection laws fall sensibly within the exceptions in the arbitration law, meaning that the worker protections laws should prevail. Again, Justice Ginsburg strongly disagreed with the majority's approach to the case. In her dissent, she pointed out that blocking joint lawsuits would deter most workers from seeking individual unpaid wage claims because of the cost of lawsuits and fear of retaliation. She warned the majority's decision would result in hurting vulnerable, low-wage workers. Now, those are the kinds of real-life impacts. The reality of women who are not paid the same as their male counterparts because of sex discrimination happening that she has no way of finding out about, or of workers who are forced to sign an arbitration clause that overrides other worker protection laws. Those are the kind of real world impacts. So do you think Justice Ginsburg was wrong to consider real world impacts in her decision making?
Well, Senator, both the case, you're talking about Lily Ledbetter, both that case and Epic Systems are precedents of the court. And as I've said a number of times during the hearing, I can't really comment or grade thumbs up or thumbs down, as Justice Kagan put it, prior precedents, or say how I would have decided them.
They are, Judge Barrett, they are precedents of the court that do not take into consideration the real world factors at play here. And in fact, in the case of Epic Systems, the court sided with the corporation as opposed to the workers who are trying to remedy a wrong. And in Lily Ledbetter, she was totally out in the cold. So again, the court did not. So they established precedent, all right, but it was a precedent that was not based on real life impacts. So much as you sit here telling me that you would follow the law, after all, the law, for example, the Affordable Care Act, that law embodies a policy that says we want as many people as possible to be covered under insurance. And if the Affordable Care Act is struck down, that policy, that law would be struck down. So I know that there was some discussion about some distinction that you make about policy versus the law. And I find that distinction to be a fiction because every law or most laws we pass are supposed to have real world impacts. Otherwise, why should we pass a law? So the fact that you're not able to, I think it's pretty clear. Let me rephrase that. You do consider Justice Scalia to be your mentor, that your judicial philosophy is in alignment with him. And I think we all acknowledge that Justice Scalia and Justice Ginsburg were at pretty much opposite ends of the spectrum. So since Justice Ginsburg made it a policy, her approach was to look at the real world impact. Justice Scalia's was not. So I'd say that when it comes to the Affordable Care Act, the real world policy considerations that will not be taken into consideration by the conservative judges would mean that 23 million people could lose their health care, that 133 million Americans with pre-existing conditions could lose critical protections for their health care, and more than 7 million Americans who have tested positive for COVID-19 would probably be added to the group of people with pre-existing conditions, and millions of Americans would once again face lifetime limits on coverage for essential services. That 8.7 million women would lose coverage for critical maternity care services. And we know that Black and Native women are 2 to 3 times more likely to die than white women from pregnancy-related cases, that Americans could lose coverage for essential health benefits like prescription drugs and mental health care, that young adults will no longer be able to stay on their parents' health insurance plan until age 26 at a time when our country is dealing with massive job losses. So in my view, you have posed an artificial distinction between policy considerations that's left up to us and following the law, because if your criticism of Justice Roberts' decision in upholding the Affordable Care Act, if that was something that he followed, he would have struck down the Affordable Care Act. That is your, if he followed your criticism of him in sustaining the Affordable Care Act, he would have struck it down. So I would conclude that your approach is in fact not like that of Justice Ginsburg, who did care about what would happen. Let me just tell you one story of a person who will be impacted in the real world if the Affordable Care Act is struck down. And I know that so many of my colleagues have already established that the president expects you to strike down the Affordable Care Act, and you've already established that you made no such commitments. But clearly that is why this whole process is occurring so that you can be sitting on that court in time to hear the Affordable Care Act by the Supreme Court on November 10th. So one of the people who will be impacted is Elizabeth from Texas. She moved to Texas for a job and thought that she would have a stable income and healthcare coverage. And all that changed when her hours decreased and she lost her health insurance. Because she couldn't afford health insurance, she couldn't get proper treatment for her asthma. She had to resort to using friends' expired inhalers and over-the-counter remedies. The ACA allowed her to get health insurance again. The ACA also protects people with pre-existing conditions like Jordan, who I talked about yesterday, and she has a very rare illness that would require $500,000 per year just for her medication. And were it not for the Affordable Care Act, she wouldn't be able to afford it. I mean, who can afford $500,000 a year to keep her going? And also people like Kimberly, I talked about her yesterday. The ACA enabled her to get a mammogram, which she wouldn't have been able to get. And that mammogram revealed that she had breast cancer and she got a mastectomy. So, this the real life impacts on people like Elizabeth Jordan and Kimberly, where you say you will follow the law, it really leaves me wondering whether all of these real life impacts are what you would call within the scope of the law that you would decide should you be confirmed. November 10th, you'll hear the case. You will be deciding on the constitutionality of the Affordable Care Act. And by the way, you noted that the issue in the Affordable Care Act was one of, what was it that you said?
Severability?
Severability. But the other issue in the Affordable Care Act is the entire constitutionality of the law, because the district court, the issue was whether the district court in Texas was correct in deeming the entire law unconstitutional. So in fact, we are facing the entire law falling by the wayside. Let me move on. So you've been also asked a lot of questions about whether or not you would overturn Roe v. Wade. I mean, clearly President Trump expects that you would do so because, as he said, if we put another 2 or perhaps 3 justices on the court, that'll happen, meaning the reversal of Roe v. Wade will happen automatically, in my opinion, because I am putting pro-life justices on the court. And a number of us have mentioned that Senator, as far as Senator Hawley is concerned, where he said, I will only vote for those Supreme Court nominees who have explicitly acknowledged that Roe v. Wade was wrongly decided. And there's a whole quote I have from him, but after you were nominated, Senator Hawley made clear that you passed his litmus test. And he said, I think her record is awfully clear. I think that's one where she meets my standard of having evidence in the record. And by the way, he had noted that he expected this evidence in the record, not from your post-nomination assurances to him. So all your prior record, he said, you met his standards. So we usually expect justices to uphold and apply longstanding precedent. So was the president wrong in concluding that you would vote to overturn Roe v. Wade?
Well, Senator, again, I can't make any statements, no hints, forecasts, or previews, as Justice Ginsburg put it, about any case or any precedent. But I will repeat what I've said, throughout this hearing, that I made no promises to anyone. I have no agenda. There are 598 volumes of the United States reports. That's something that judges build on. Justices don't go to the court to start having a book burning.
I know that you have reiterated that time and again, but what we are left with are the positions that you have already taken. So the 2006 newspaper ad you signed that said you, quote, oppose abortion on demand and defend the right to life from fertilization to natural death. It's not just the fact that this newspaper ad you joined said what I just read, but it also said, quote, it's time to put an end to the barbaric legacy of Roe v. Wade. In a 2013 speech you gave where you said the Roe decision, quote, permitted abortion on demand, end quote, after you said you opposed abortion on demand in 2006. So what underscores my concern about your willingness to overturn Roe v. Wade, which is really the expectation that the president has and which Senator Hawley fully expects you to do because you have met his litmus test. But you noted stare decisis, which is precedent. And you have argued that a justice's duty to follow the Constitution, which you explain means that she should, this is regarding your view on precedent, that she should, quote, enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it, end quote. So in fact, you say constitutional cases are the easiest to overrule because you bring your own assessment of what the Constitution requires. And as you said, if the precedent is clearly in conflict with your view of the Constitution, then the precedent falls by the wayside. So you did indicate that there are a few cases that are immunized from overturning because they wouldn't be challenged in the first place, i.e. Brown v. Board of Education. But Roe isn't one of those cases because we know that there are all kinds of challenges to Roe, basically because the states are very busy passing all these laws that limit a woman's right to an abortion. So You also said in that speech that even if Roe is not overturned, you said, without overturning Roe, you explained, quote, the question is how much freedom the court is willing to let states have in regulating abortion. And so there are 14 cases right now relating to state abortion restrictions making its way through the circuit court, and some of these are going to land in the Supreme Court. And these 14 cases include the following restrictions. 6 cases involve bans on abortion starting at gestational ages ranging from 6 to 24 weeks. 2 cases involving bans on a particular type of procedure, dilation and evacuation, that accounts for nearly all second trimester abortions. 1 case involving a requirement that fetal remains be buried or cremated. 4 cases involve laws imposing unnecessary requirements on abortion providers, like transfer agreements with local hospitals. 4 cases involve so-called reason bans. 2 cases related to parental notification and consent. There are real reasons why the American public is concerned that you will overturn Roe or basically strip it of all meaning so that it becomes a nullity, because you will have these cases that, as you say, the open question is how far the Supreme Court will go in letting states put limits on abortion. So that is why a lot of people are very concerned about your views as articulated pre-nomination, which convinced Senator Hawley you met his test. This morning, Senator Feinstein asked you a question about the Supreme Court's 2015 decision in Obergefell v. Hodges, a case in which the court recognized the constitutional right to same-sex marriage. And I was disappointed that you wouldn't give a direct answer on whether you agreed with the majority in that case, or if you instead agree with your mentor, Justice Scalia, that no such right exists in the Constitution. So even though you didn't give a direct answer, I think your response did speak volumes. Not once, but twice. You used the term sexual preference to describe those in the LGBTQ community. And let me make clear, sexual preference is an offensive and outdated term. It is used by anti-LGBTQ activists to suggest that sexual orientation is a choice. It is not. Sexual orientation is a key part of a person's identity. That sexual orientation is both a normal expression of human sexuality and immutable was a key part of the majority's opinion in Obergefell, which, by the way, Scalia did not agree with. So if it is your view that sexual orientation is merely a preference, as you noted, then the LGBTQ community should be rightly concerned whether you would uphold their constitutional right to marry. I don't think that you use the term sexual preference as just, I don't think it was an accident. And one of the legacies of Justice Scalia and his particular brand of originalism is a resistance to recognizing those in the LGBTQ community as having equal rights under our Constitution. In 1996, Justice Scalia wrote a dissenting opinion in Romer v. Evans defending a state's ability to openly discriminate against the LGBTQ community. In 2003, Justice Scalia wrote a dissenting opinion in Lawrence v. Texas defending a state's right to criminally prosecute someone for same-sex sexual activity. 10 years later, in U.S. v. Windsor, Justice Scalia wrote another dissenting opinion, this time defending the federal government's right to deny federal recognition of same-sex marriages. And of course, 2 years after that, in Obergefell, Justice Scalia wrote yet another dissent, and this time he argued that there was no constitutional right to same-sex marriage. So under Justice Scalia's judicial philosophy, which you have told us is your own, states could openly discriminate against the LGBTQ community. Same-sex couples could be denied the right to get married, and they could actually be thrown in jail if they engaged in sexual intercourse. There are an estimated 11 million adults who identify as LGBTQ living in this country since Obergefell was decided in 2015. Approximately 293,000 same-sex couples have gotten married. And many of these people are rightly afraid that if you are confirmed, you will join with other conservative members of the court to roll back everything the LGBTQ community has gained over the past 2 decades and push them back into the closet. Now, 2 sitting justices are already calling for Obergefell to be narrowed, if not outright overturned. Just last week, Justices Thomas and Alito issued a statement concurring with the court's decision to deny cert in Davis v. Irmo, a case involving a former Kentucky County Court who refused to issue marriage certificates to same-sex couples. They accused the court of, and this is Justices Alito and Thomas, they accused the court of, quote, reading a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text. And these 2 justices signaled that Obergefell is a problem that only the court can fix. So, coupled with your use of the term sexual preference, coupled with your view on precedents, and that a justice's view or her own analysis of the constitutionality should overtake or overcome precedents if it's in conflict. So this is why so many people in the LGBTQ community are so concerned that you would, in fact, join the signaling that these 2 justices have already put out there, that Obergefell will fall by the wayside. Thank you, Mr. Chairman.
Thank you. Senator Ernst.
Thank you, Mr. Chair. And Judge Barrett, thank you so much for being here today with your beautiful family. Yet once again, we appreciate the support that you are showing to Judge Barrett by being here today. And Judge, I just want to offer you the opportunity at this point. Is there anything from earlier today that you feel you need more time to respond to?
Thank you, Senator Ernst. I would like to just make a quick follow-on to some of Senator Hirono's comments. One, I've said a number of times during the hearing that I can't comment or grade existing precedent. And I want to be clear that the point of doing that is not to say whether I agree or disagree with it. It's not to implicitly signal that I do disagree with it. It's designed to be neutral. So in saying that I couldn't opine on whether Obergefell was rightly decided or not, I was certainly not indicating disagreement with it. The point of not answering is to simply say it's inappropriate for me to say a response. And the second point was to say that I certainly didn't mean and, would never mean to use a term that would cause any offense in the LGBTQ community. So if I did, I greatly apologize for that. I simply meant to be referring to Obergefell's holding with respect to same-sex marriage.
Thank you for that. I appreciate the clarification. And it goes back to the discussion that you had with Senator Sass on the black robes. When you put that robe on, you are neutral, correct?
Yes.
Yes, thank you. So I did want to go back because clarify that the Senate GOP did bring up a relief bill a number of weeks ago. And in that bill, there was a $300 boost in weekly unemployment insurance benefits. There was a second pass at Paycheck Protection Program for our small businesses. There was additional $105 billion for K through 12 schools and colleges with new scholarship programs, and $15 billion to help working parents find accessible childcare options. There were supports for farmers and ranchers impacted by the pandemic. There was $31 billion for development and distribution of vaccines, drugs, and other medical supplies, $16 billion for testing and contact tracing. There was loan forgiveness for the Postal Service, liability protections for our schools and healthcare providers, and an expanded charitable deduction for contributions made during this pandemic, and many, many other things. It was a very, very good bill. It was what we could agree upon, but I would note that Senate Democrats did block those provisions that would have gone to help families like Veronica and others in Iowa that are suffering from the pandemic, and of course, our greatest sympathies to those that have been impacted all across the United States. So, Mr. Chairman, I would like to enter into the record, there's 3 letters here for the committee and an op-ed, a letter of support from 48 Christian women scholars. The second is a letter from a group of governors all across the country, including our own Iowa's Governor Kim Reynolds, strongly supporting the nomination of Judge Barrett. The third is a record letter from Tracy Lovett, who was with Judge Barrett while they both served on the SCOTUS clerk class of 1998. And then there's also an editorial by Derek Moeller, a professor of law at the University of Iowa College of Law, that appeared in the Gazette of Cedar Rapids, Iowa. And this professor had Judge Barrett as his evidence professor at Notre Dame Law School. And he does say she treated all law students from all backgrounds with dignity and respect. If I could have those entered into the record.
Without
please.
objection.
Thank you. And Judge Barrett, I am pro-life. I am pro-life. And I see that, judged by your faith, and as has been aptly pointed out many times over by our colleagues across the aisle, that you are pro-life. But once again, can we reiterate your stance as a judge?
So as a judge, my personal moral beliefs, which I have not, that I can think of, I'm not expressing them publicly right now, because now that I am a judge, I can't sign statements like that one that I did 15 years ago. But my policy views, my moral convictions, my religious beliefs do not bear on how I decide cases, nor should they. It would be, and it would be in conflict with my judicial oath.
And I know that you consider yourself to be an originalist, as you discussed earlier with Senator Sass. And it seems that adhering to the originalist view would naturally lead a judge to carry out her constitutional duty of impartiality when applying the law. And adhering to this philosophy as a judge takes real courage. And the courage you have displayed thus far as a federal judge prompted a coalition of groups to send me a letter supporting your nomination. Susan B. Anthony List led this coalition letter that I would like to submit to the committee for the record. And I know this is going to make a number of members on the committee just very squeamish because they are a pro-life organization. But with this in mind, I want to take a moment to read part of this letter. Quote, Judge Barrett has proven herself to handle disputes impartially, approaching cases as a textualist and originalist who loves the Constitution. She is a jurist who rightly leaves politics to politicians and legislating to legislators. And I'll quote further. Quite apart from whatever policy views she may have on the matter, Judge Barrett reasons to a proper result in each case before her. As a federal appellate judge appropriately following controlling precedent, in February 2019, she joined a panel decision upholding a law creating a buffer zone around abortion facilities. This buffer or bubble zone case being referred to is Price versus City of Chicago. Judge Barrett, could you please give us an overview of the city ordinance that was challenged here and explain how precedent established by the Supreme Court's Hill decision influenced your reasoning of the case?
Yes, I was on a panel. There was a challenge to a bubble zone ordinance, which essentially means it was, how to describe it, it limited where abortion protesters could go to do sidewalk counseling or leafleting with the things that they identified as the activities they desired to undertake in the expression of speech outside of the abortion clinic. The Supreme Court has a case called Hill versus Colorado, and that case said that such bubble zones, especially because this one in Chicago was nearly identical, as I recall, with the one that was at stake in Hill, said that they did not violate the First Amendment. And so our panel, we're bound by that precedent. Our panel applied that precedent. And so as you say, that was a case involving abortion, but my duty as a judge was to follow the governing law, and that governing law in that case was Hill.
Absolutely. And thank you for that clarification. And I think it was important to point that out because in that case, using precedent, it did favor that abortion clinic. Is that correct?
That is correct.
Thank you very much. So I would like to submit this for the record. Thank you. Now turning to a topic of agency rulemaking, really sexy topic, not something that we have talked about as of yet. But as I mentioned yesterday, when Congress makes laws that overstep the Constitution, it can be felt all across the state of Iowa, whether it's in the streets of Council Bluffs, Iowa, or in the farm fields over in Clinton County. But Congress isn't the only body capable of overstep. Executive agencies can be just as guilty of this as we've seen in Iowa. In 2018, as a judge on the Seventh Circuit, you helped decide a Clean Water Act case, specifically Orchard Hill Building Company versus Army Corps of Engineers. The decision found that the federal government did not provide enough evidence to justify its decision to deem 13 acres of Illinois wetlands as a water of the U.S. I'm very supportive of a less expansive definition of WOTUS and am encouraged by how you approach this decision. Farmers in Iowa are also encouraged by this development. I believe then, as I do now, that the Obama administration's Clean Water Rule, or the WOTUS rule, was unconstitutional. But I also want to talk to you about agency rulemaking that I believe was constitutional, which is illustrated in a case that the 10th Circuit Court has recently ruled on, specifically Renewable Fuels Association versus EPA. At issue in this case were 3 exemptions the EPA granted to oil companies, allowing them to avoid their obligations to blend renewable fuel under the Clean Air Act's renewable fuel standard. These oil refinery exemptions, which were not disclosed to the public, were challenged by renewable fuel producers who said that they only found out about the waivers because of investigative news reports. The 10th Circuit concluded in this case that the renewable fuels producers were injured by the EPA's exemptions and thus had standing to sue. The court also found that the EPA exceeded its statutory authority in granting those petitions because the agency may only extend previously existing waivers. In the case of these 3 refiners, there was nothing to extend because they had let their exemptions lapse. In other words, the 3 refineries had not received continuously extended exemptions in the years preceding their petitions as required by the statute. However, in the wake of this 10th Circuit decision, small refineries flooded the EPA with 67 petitions for retroactive waivers, some dating back as far as 2011, in an attempt to go back in time and establish a chain of continuously extended exemption. These oil companies have also appealed to the 10th Circuit decision to the Supreme Court. So while I'm not going to ask you to speak on all of this and what is going on, the problem here, bottom line, is that the EPA wasn't following the law. They took the law that Congress passed, they twisted it and interpreted it for the benefit of oil producers, and that harmed our Iowa farmers. I know, again, you can't speak on how you would rule on these cases, especially those that could be pending before the Supreme Court. But tell me, how should they interpret the laws that are passed by Congress?
Well, I think that the court's role in reviewing the lawfulness of agency action, it's largely governed by the Administrative Procedure Act, which governs the way that agencies can do their business and outlines what their authority can be. There's also a doctrine called Chevron, which is named after a case. And many times, if we're talking about a Chevron issue, we're talking about an issue of statutory interpretation. It sounds like that's mostly what you're thinking of. And an agency, when a court reviews whether an agency has exceeded its lawful authority, it goes to the statute that you and Congress enact and interprets that statute, looks at the text, and tries to tell whether you've given the agency, given the EPA in your example, leeway to adopt policies. And that leeway would be present if you had ambiguity in the statute that left the decision to the agency. But if the agency goes farther than the text of the statute permits, then it is the role of a court to say that that action, was in conflict with the statute and therefore illegal.
And what happens then if there is an actual question on the intent of the law?
Well, a statute in this context, in a context of a Chevron type challenge to an agency's interpretation of it, you would interpret the statute in the same way that you would interpret any other statute. So as I was talking with Senator Sass about earlier, my own approach to it would be textualism. And so in my approach to language, the intent of the statute is best expressed through the words. So looking at what the words would communicate to a skilled user of the language.
Very good. Well, I appreciate it. We do have a little bit of time remaining. So again, I just want to thank you. I want to thank your family very much for lending their support to you through this process. It can be a bit grueling. But I do have to say, though, your temperament throughout the entire hearing has been truly commendable. So thank you so much. I look forward to working with you further. And with that, Mr. Chair, I will reserve my time.
Thank you, Senator Ernst. Judge, are you okay to do two more?
Sure.
So Senator Booker, Senator Crapo, then we'll take a 20-minute break to grab a bite to eat and finish up. Senator Booker.
Thank you, Mr. Chairman, Your Honor.
Hi, Senator.
So I spoke yesterday, and I appreciate the attention which you gave me talking about how this is not a normal time. And I want to reiterate that one more time as cogently as I can, because this is something like we've just never seen before in the history of the United States. We're not just days away from Election Day, but people are actually voting right now. Close to 1 million people in my state have already voted, and about 10 million people voted nationally. The only other time a Supreme Court nomination hearing happened this close to an election was, as you probably know, was under President Lincoln, who declined to offer a nomination before the election. But we are in the midst of an ongoing election right now at a very contentious time in our democracy. It's probably not normal also because people are already speaking in this election, and it seems like we are rushing through this process when many of my colleagues on this committee said just 4 years ago that we should not proceed to fill a vacancy that opened 269 days before an election. And the words of some of my colleagues, including the chairman, was to use our words against us. We would not do exactly what we're doing right now. It's also not normal, clearly, because we're in the middle of a pandemic. And we have tens of thousands of new COVID infections every single day, widespread food insecurity like we haven't seen these kind of food lines in my lifetime, I don't think. People across our country are struggling, and unfortunately, we see that we are right now not dealing with this crisis. We are instead literally having closed the Senate virtually, and the only proceedings that are being allowed to go forward are not the issues of helping people who are struggling, but dealing with this. And it's not normal that we have a president who has repeatedly attacked the legitimacy of our institutions. So much so, and I've never seen something like this in my lifetime, that his former cabinet members, his former chief of staff, all talk about the danger he represents to the country we all love. In fact, probably one of the most respected person on both sides of the aisle, General Mattis, who served as our Secretary of Defense, went as far as to say, a man who has been very reserved in his comments, that Donald Trump is a danger to our democracy. We are at a time that the legitimacy of our institutions are at stake. And it's not normal that the president would further cast a shadow over your nomination as well as the independence of the court by saying he would only nominate justices who would tear down Roe v. Wade, who would overturn ACA. And it's not normal amidst this all. And again, something that I find hard to believe that we're talking about is that we have a president who cannot commit himself to the peaceful transfer of power.